Today is Thursday, February 15th, 2024, and I am blown away by the hearing today on misconduct allegations against FANI Willis. I had no idea it would be this easy, but Nathan's testimony is a example of the truth being an absolute defense 100% of the time, regardless of what is exposed. And the truth is necessary, the good, the bad, and the ugly, in order for justice to be served. But I wanted to share some clips from the testimony that I think show that folks do not appreciate the precedent they are setting in the kind of interrogation that they are doing with Nathan. And you compare it to women who have filed lawsuits for sexual misconduct against politicians or celebrities, and how their testimony is viewed, and also how those testimonies are disregarded if a politician is involved, and how the person is discredited, to how they are questioning Nathan. The thing about Nathan's testimony, though, is because of the kind of evidence they're allowing and then interrogating him about, which he's being very forthright in answering, quite frankly, it shocked me. Once the precedent is set, then they can turn that back around on the judicial system in the Trump case, in any other kinds of political cases where they can use substantive evidence that involves extramarital affairs and all that kind of stuff, to really discredit the person, and to force them to testify about things that will inevitably expose the political or government corruption. So let me just share those clips, and and then you come to your own conclusion about that.
Now, when you talked about your relationship with Miss Willis, and your testimony is that it began in 2022. You remember that testimony?
No, sir. Our relationship began in
your romantic relationship began with Miss Willis, and your testimony is that it began in 2022. You remember that testimony?
No, sir. Our relationship began in
your romantic relationship began in 2020. Miss Willis, and your testimony is that it began in 2022. You remember that testimony?
No, sir. Our relationship began in
your romantic relationship began in 2022.
Yes, sir.
That's your testimony?
Yes, sir.
Okay. Now, when you were re-upped on this
Yes, sir.
And I'm going to also, of course, try not to go back into specific questions that have already been asked. Okay?
Yes, sir.
When did your relationship with Miss Willis end?
2023.
Can you give us an approximation of, not by date, but by month?
Summer 2023. Forgive me. I'm a man. We don't do the date thing. Summer 23, I would say June, maybe.
Okay. Using the euphemism personal relationship, did you have any personal relationship at all with Miss Willis after the summer of 2023?
I want to make sure that I'm answering your question. Are you, because
let me rephrase, if I might. The way it has been characterized in, for example, the response of the state, and I believe in your affidavit, is there's a difference between a personal relationship and a professional relationship. Correct?
Yes, sir.
Okay. I'm not talking about a professional relationship. I'm talking about a personal relationship. Have you had a personal relationship at all, and you know what I mean by that, after the summer of 2023?
Are you asking me if I had intercourse with the district attorney?
I was trying not to, but I guess if you're going to characterize it as that, the answer would be...
The answer would be no.
So it's been purely professional since the summer of 2023.
So that's where we're having issues.
Okay, you'll have to explain because I don't know what the issue would be.
No, I will explain to you.
Thank you.
You say personal. We're very good friends, probably closer than ever because of these attacks. But if you're asking me about specific intercourse, the answer is no.
How about if I change it from intercourse to romantic?
No. Wait. If you're asking me if people knew that we were having sex, no, they didn't.
I'm asking you whether the people knew that you were dating, whether you were romantically involved. You said that it was not a secret.
Oh, it wasn't a secret. It was just private. My mother knew, obviously.
Okay. Did anyone in the district attorney's office that has worked on this case know that you were dating or had a romantic relationship with District Attorney Willis?
I don't know what they knew.
Well, did you tell anyone?
No,
Do you have any knowledge of whether Ms. Willis revealed it to anyone?
I have no clue.
Okay. So as far as you know from personal knowledge, no one in the DA's team knew, correct?
That's correct.
Okay. So if it was a legitimate relationship, is there any particular reason why it was kept secret or private?
It wasn't kept secret. It was kept private.
And the purpose for that was?
It's what we chose to do.
I'm asking you why, though, not just because you chose. Why, if you're dating someone, why keep it private?
So, a few reasons. The first one is, and I want to say this respectfully in the right way, there are some people who are in the public eye who just don't like it, don't wish to be there. I have tried to have lunch or dinner with her publicly, and I can't count the number of people that would approach the table or would accost us as we're trying to walk into a restaurant and just have lunch or have a meal. It is not secret, it is private. We don't want the world asking questions or interrupting that time. So we weren't trying to keep anything a secret, Mr. Sadal. There's nothing secret or salacious about having a private life. Nothing.
After you were hired, right?
Okay. I'll answer your question.
Okay, please.
So in 2015, when my wife had the affair, we had a conversation that we would divorce right then. Again, the better practice, at least for my children at the time, was to stay in place until the youngest could graduate and matriculate into college. We did that. When she graduated, matriculated into college, at the time my wife had moved back and forth to Houston, to Texas. So she's in Texas. We matriculate into college. We did that. When she graduated, matriculated into college, at the time my wife had moved back and forth to Houston, to Texas. So she could graduate and matriculate into college. We did that. When she graduated, matriculated into college, at the time my wife had moved back and forth to Houston, to Texas. So she's in Texas. We take our child off to college. We come back to Georgia for a brief period of time. Divorce gets filed. She gets served. There we go. Now, the reason that date was selected.
Yes, sir. That's what I asked.
The specific reason that specific date was selected was because she was only in town for a brief.
Your Honor, this is attorney-client privilege. Why he out whether it covers the question you were trying to get to.
And if I may finish, and your position is you have no intention of waiving your attorney-client privilege, correct?
That's correct.
All right, so now, can you answer the question why you waited until November 2nd, the day after you were hired by Ms. Willis, to file for divorce?
I can.
Okay.
So, again, Joycelyn had relocated to Texas, and she had been in Texas for months. She was only here for a brief period of time to drive my daughter's car back with her. And when she came here to do that, I was able to then get her served.
Okay, so your answer as to why you waited until the day after you were hired by Ms. Willis, which would be November 1st, 2021, to file the complaint for the divorce on November 2nd, 2021, your testimony under oath is because your wife was here. But had not been here in October, had not been here in September, had not been here in August of 20.
Overruled.
I'm claiming privacy.
The privilege that you make reference to is to infamy, disgrace, or public contempt upon the witness, right? Or party. That's the section that you were relying on, correct?
If that's what it says, yes, sir.
Okay, well, I could show you, but I think the court has already indicated he can take judicial notice of the statute. So you assume that what I'm telling you is accurate, okay?
Yes, sir.
Okay. How would an answer of none bring infamy, disgrace, or public contempt upon you?
So, as I explained in direct of Mr. Roman's counsel, the minute she elected to intervene into my divorce proceeding, I then started to understand the bigger picture, which was that all the attorneys in the election interference case were colluding with Joycelyn's divorce lawyer, and because of that, I said, privacy. I don't want my divorce proceeding to bleed into this criminal proceeding. I just didn't want that.
So you raised a privilege, if I understand, that indicated that your answer would bring infamy, disgrace, or public contempt upon you, right?
Your Honor, I'm going to object to the relevance of this.
Asking you now is the answer to that interrogatory.
The answer is
none.
The answer is still privilege.
All right. So he's apparently electing to apply the same privilege, Mr. Sadow, to that exact same question.
And I have a case which indicates that we can get beyond that if the court deems that appropriate.
And to what end? To what end? Where?
That the privilege actually does not apply and he must answer the question.
And where does that get us? Even if he answers the question, hasn't he already kind of said everything as the nature of the relationship, how long it lasted, when did it end?
No, I think it would prove. I think if he is forced or compelled to answer the question, he will either answer it falsely by saying none, or he answer it truthfully by saying yes, and then telling us what it is. That's what I believe. That's why I'm asking.
But the interrogatory you're referring to, though, the question contained there.
Two interrogatories, yes, sir.
It's the entertaining one. It's whether there were other relationships, right?
With a specific language that's in the interrogatories.
Sure. Haven't you already covered that in all the other questions that we've had so far?
But we have, but again, the court could, if I could require or compel an answer from him as to whether his answer would still be none, then we would know whether or not he was telling the truth now. If the answer is no, then obviously there was a time in the past where he was not. It simply requires him to now answer under oath what he refused to answer and claimed, what I might suggest, is a bogus privilege, and that you can pierce that privilege because it's a material fact in connection with this case. Again, it's a call that Your Honor makes. I have the case law that says you can do that.